Nyindam as Member of Parliament elect for the Kpandai constituency pursuant to the parliamentary elections held on the 7th of December 2024. Honourable members, the effect of the order, to my understanding, is that the Electoral Commission is to conduct a rerun election within 30 days, implying that the original declaration of Honourable Matthew Nyindam as the winner of the parliamentary election is invalid, and the member is no longer a member of Parliament. I, however, bring to the attention of the House the provisions of the Court of Appeal Rules 1997 CI-19 as amended in the Court of Appeal Rules 2020 CI-132, Rule 27(3), and it provides as follows. I quote, "There shall be a stay of execution of the judgment or decision appealed against for a period of 7 days immediately following the giving of notice of the judgment or decision," unquote. This rule appears mandatory in its terms and applies in every High Court decision capable of appeal. The Supreme Court in Mensah versus Ghana Commercial Bank, 2005 to 2006, Supreme Court Ghana Law Report, at page 388, held that any execution commenced before the expiry of this 7-day period is premature and void. The Court of Appeal reaffirmed this position in Clenham Construction Limited versus Falcon Crest, the 7th of April 2022, emphasizing that the purpose of the statutory stay is to allow the losing party the opportunity to consider the judgment and determine whether to appeal or seek further relief. Justice Ba J.A. explained the position of Lord Das, and I quote him, "The plain meaning, scope, and effect of Rule 27(3)(b) CI-19 is that in respect of any ruling, judgment, or decision of the High Court of whatever description, in respect of which an appeal can be filed, and further, in respect of which an application for stay of execution or proceedings could be filed, they shall operate a statutory stay of execution or proceedings for a period of 7 days. The apparent intent of the law is to enable the vanquished to ponder over and scrutinize the bona fides of the ruling, decision, or judgment in order to decide on whether or not to appeal. It is when a decision is made to appeal that an application may be made to the High Court under Rule 27(1)(a) of CI-19 or to this court under Rule 27(1)(b) CI-19, unquote. In this instance, the ruling of the Tamil High Court was delivered on the 24th of November 2025. The statutory 7-day stay therefore remains in force until 1st December 2025. 2025. During this period, the High Court's ruling cannot form the basis for the Speaker to instruct the clerk to notify the Electoral Commission that the Kpandai seat is vacant. In addition to the above, should Honorable Nyindam exercise his right of appeal, such as an application under Rule 27(1) of CI 19, it may impose a further suspension on the enforcement of the judgment until the application is determined by the appropriate court. This rule appears to prevent the subject matter of the appeal from being altered or prejudiced while the appeal processes are pending. Therefore, before the initial 7-day statutory stay, the filing of a stay application may yet introduce an additional layer that may prevent changes to the member status within the meaning of Article 97 and 99 of the Constitution. The House's attention is also brought to Article 105 of the 1992 Constitution, which provides that a person who sits or votes in Parliament, and I quote, knowing or having reasonable grounds for knowing, unquote, that he is not entitled to do so, commits an offense. It is crucial to emphasize that Article 105 is penal in nature should the member know that he ought not to be in the chamber and he participates in the activities in the chamber. Honorable members, it's therefore too much premature to say that the Honorable Matthew Nyindam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7 days mandatory stay of execution of the order. Honorable members, this is not a declaratory order. It is an executive order that was delivered by the High Court. And so the honorable member is right to have been in the House yesterday and to have participated in the proceedings.